Do you want to? Yeah, Mr. Chairman, I just want to pick up a couple of points and to concur in some respects with my friend and colleague David Clendon, but also to disagree in others. First of all, the critical thing about parole is that it is absolutely necessary in terms of reducing the risk of reoffending by those released from prison. We have had the phenomenon of people being returned from Australia who are not subject to parole conditions and about whom we don't have sufficient information, and that's a real concern. That's something else that I hope that the Minister can pick up. Good luck with that. I struggled with the state and federal level of the Australian government to try to get that information, and they said nice things and did very little, but it is something that we absolutely need to address. But I'm saying that, Mr. Chairman, to highlight the fact that while some people say, truth in sentencing, if you're sentenced to 6 years, you should serve right up to the last day, all of the evidence that is available to us, as David Clendon also pointed out, is that where people are released at the end of their sentence without provisions for parole and the conditions associated with parole, the level of reoffending by those individuals is much higher. The huge advantage of parole, well, there are two huge advantages. One is that there are a lot of people in our prison who, when they've served a large part of their sentence and they've done the rehab courses, they're not going to reoffend. At that point, keeping them in prison serves very little purpose at a very high cost. So parole, if we abolish parole tomorrow, as sometimes the ACT Party and sometimes the right wing of the National Party recommended, that would come to hundreds of millions of dollars. And the reason why perhaps the National Party is a little bit more reform-minded is because the Minister of Finance is conscious of how much the prison system costs to run. But the much more important thing is that when a person is released on parole, they are released on conditions. They must report, for example, weekly to their local parole office. They talk to their probation officer. They are under oversight of the probation officer. They may be subject to conditions as to where they live, as to where they work and who they can associate with. So the point about parole is that it actually enhances the safety of the community. And if you didn't have parole and there was the so-called truth in sentencing, actually our offending rates would be higher, people would be less safe, and the system would be a whole lot more expensive. Where I still have trouble coming to terms with the Green Party minority view is that I'm not quite sure specifically what it is the Green Party is objecting to in this legislation. Because as I pointed out before, the Parole Board and the people that we would respect on the Parole Board very much supported this legislation and made the point for any law and order warrior that while you extend the period of time between parole hearings, this was not likely to result in longer periods in prison and indeed may well result, Justice Gendel said, in less time in prison. I want to note too that the Parole Board does have the ability and the inmate has the ability to bring forward their parole hearing within the flexibility that this system provides. And where a person has met the objectives set for their rehabilitation, either the manager of the prison or the offender can apply to have an earlier parole hearing. And that makes sense as well. So flexibility works both ways. But the important thing about it is that with that flexibility, one of the new requirements on the Parole Board set out in this bill is that the Parole Board must set the date when the next hearing will be heard by, and also identify the activities that the offender needs to address. And when they do that, they provide that information not only to the offender, to the prison manager, but also to the police and the victim. So the victim is kept better informed about where the offender has got to and what they still need to achieve before they can be considered for release. And I think that that is very positive, sir. I think that the other things that are set out in the bill are largely, they're not designed to disadvantage the offender, they're designed to make the system more effective so that attendance at hearings can be by phone or video conference, and that applies more and more in the justice system, and that's a
Jamie
good
Lee
thing.
Ross. The question is that the question be now put. Those of that opinion will say aye.
Aye.
To the contrary, no. The ayes have it. The question now is that parts 1 and 2 and clauses 1 to 3 stand part. Those of that opinion will say aye. To the contrary, no. The ayes have it. A party vote's called for. Ask the clerk to conduct a party vote.
New Zealand National.
59 in favour.
New Zealand Labour.
32 votes in favour.
Green Party.
14 votes against.
New Zealand First.
11 votes in favour.
Māori Party.
2 opposed.
Act New Zealand.
1 in favour.
United Future.
1 in favour.
Members, the ayes are 94, the noes are 16. Parts 1 and 2 and clauses 1 to 3 will stand part. I will report this bill without amendment.
The House is resumed.
Mr Speaker, the committee has considered Energy, Fuels, Levies and References Amendment Bill and reports the bill without amendment. The committee has also considered the Gambling Amendment Bill number 2 and reports the bill with amendment. The committee has also considered the Parole Amendment Bill and reports the bill without amendment. Mr Speaker, I move that the report be adopted.
The question is that the report be adopted. Those of that opinion will say aye. Aye. To the contrary, no. The ayes have it. The Energy, Fuels, Levies and References Amendment Bill and the Gambling Amendment Bill number 2 and the Parole Amendment Bill are set down for third reading next sitting day. The House stands adjourned until 2 p.m. tomorrow.